The New York Times recently wrote an article about how lower court judges, the inferior judges, are baffled by how to apply the Heller and Bruen methodology because apparently they don't understand how to apply history, which is most odd since basically all legal reasoning and actually factual trials are based on, history and understanding history. Let's break it down when we get back. Hey folks, I'm Mark Smith, host of the Four Box of Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and author of Israel Disarmed, What the 10/7 Attacks on the Israelis Teach We Americans About the Right to Bear Arms. Check it out on Amazon. All right, so the New York Times recently wrote an article entitled, Supreme Court's Gun Rulings Leave Baffled Judges Asking for Help. Now, that's true in the sense that they're anti-gun judges that are trying to play dumb. And that's what I think is really going on here. And I want to talk about this for a few minutes. The reality is that most judges, not all, I don't think, but most judges on the federal bench are smart enough to understand what's going on and to be able to apply the Heller-Bruen methodology if they try hard enough and think long enough about it. But there's criticisms by people that hate guns, hate our Second Amendment, and want to rewrite American law in a progressive way that eviscerates the most fundamental rights that we enjoy as Americans. And I don't just mean those rights found in the Bill of Rights, but I mean the rights that we benefit from the structural Constitution, the checks and balances between the Congress, the White House, the President, and the courts. Indeed, that's why we see the progressive left trying to do things to the court because they don't like its independence. What they don't understand that the Supreme Court and the federal courts are an independent branch of the three branches of government. But remember, the left doesn't want there to be elected officials or a branch of government. What they really want is the unelected bureaucracy, the deep state, to have authority by appeals to so-called experts to do whatever they want to do and tell us how to live our lives, notwithstanding any elections, notwithstanding any federal judges. And that is really the fight that's taken place in American life today as I see it. It's not even about political parties. It's about the deep state bureaucracy that gets trillions of dollars to boss over us, and they don't want to lose that power. And they certainly don't want to lose that power to elections. But nevertheless, I digress. So let's go back to this New York Times article, where it's talking about judges not understanding how to apply history. Now, before I get into a couple specific criticisms of the points made by some of these judges that claim they don't understand history, I want you to think about this from a common sense point of view for just one moment. What exactly does a judge do? What exactly does a court do? Well, if you think about it, at its most basic level, judges and courts are all about history. What do I mean by that? Well, at the most basic level, of course, when a judge or any politician, for that matter, or any elected official, and any judge across the country, when they're sworn in, they place their hand on the Bible or some equivalent from their point of view, and they swear an oath to, among other things, to uphold the United States Constitution. Well, the United States Constitution was created, ratified, and written, understood, right, put together in the late 18th century. So for these judges who say they don't understand how to apply history or they don't really like being historians, just think about the absurdity of the statement on its face. They're literally saying we have sworn an oath to uphold a 250-year-old document, the Constitution. And yet we are at the same time saying we judges are too dumb to understand what the Constitution means because it took place in the past. It took place in history. So my question is this. If you're not smart enough to understand and apply the most fundamental legal document, the supreme legal document for that matter, the Constitution, that's almost 250 years old, how are you possibly smart enough to apply the National Firearms Act from the 1930s, which is a much younger document, much younger law, or the Gun Control Act from 1968, over 50 years old, a much younger law than the Constitution? So when they say that we as judges are not capable of being historians, they're either morons or they're BSing you. They're feigning ignorance because they don't like to rule in favor of the Constitution because they want the power to do what they want to do. They want the power to say that gay marriage is, we like gay marriage and we're going to foist it upon you whether we like it or not, whether it's in the law or not, because we think it's good. They want the power to ban guns and to uphold gun bans because they like it. They don't want to have their power hamstrung or limited or constrained by the United States Constitution. So they're feigning ignorance by saying that we're not capable of applying the Constitution because it's an old document. But of course, that's a bunch of hooey. So, with that out of the way, let's also think about the other part of what courts and judges do. Well, just think about it from the most basic level of like a murder trial. Now, this is a more recent history, but think about it. Every day there are trials over whether or not people committed a murder. Did they commit a robbery? Did they commit the crime? Has the crime been going on for decades? Right? I mean, look at the Donald Trump stuff in New York. He's been charged with stuff going back decades. Okay? So the point is, what exactly is the purpose of a trial? We know what the purpose of a trial is. It's to go back in time into history and figure out whether or not who did it, who done it, how was it done, could it have been done? What is the purpose of this testimony of witnesses? They're testifying about what happened in the past, i.e. in history. So the entire legal system, everything a judge does, in fact, everything a jury does, is about looking back in time to history, either to find the right law in history that's already been on the books, that was enacted in the 1930s, the 1960s, the 1980s, the 19th century, or yes, even with the U.S. Constitution going back to the late 18th century. So they're always looking back in history for the law to figure out the applicable law, and then at the same time to figure out the applicable facts, they have to look at the history and maybe more contemporary history, but they're still looking at history. So the idea that judges say they're not smart enough to be historians is utter BS. It's a cop-out, or it's feigned ignorance because they don't like the outcome of upholding the right to keep and bear arms. But let's go beyond that. This article also references, of course, the so-called text, history, and tradition test. Now, I want to correct you again. I don't want to correct you per se, but I want to correct what's out there. Before the Bruen test, and this is important to understand as we've talked about before, Bruen is not a new law. Bruen is not newfangled. Now, this New York Times article actually says specifically that in 2022, Justice Clarence Thomas introduced a new test to assess the constitutionality of laws meant to address gun violence. Hooey, no, false, ignorant, nope. The Bruen methodology was simply a reiteration of the existing Heller methodology that the lower courts had been refusing to apply, again, out of feigned ignorance, because they didn't like the outcomes of upholding the right to keep and bear arms. So it's not a new test in 2022. It is the old 2008 Heller test, boiled down for ignorant judges or judges that refuse to follow the law and written in a paint-by-numbers way so that the lower court judges can finally get it right. Now, of course, judges don't like this, and they're going to have to be spanked repeatedly by the U.S. Supreme Court, and I think that's going to be happening. But we're not there yet. So again, I bring this up because between 2008 and 2022, there was a discussion of this so-called text, history, and then tradition test. It wasn't wrong. It referred to the text of the Second Amendment controls, but then you also look at historical laws to see if there's any sort of rules against or exceptions to, like you can't use a gun to commit murder, for example. That's based in long-standing history, going back, hundreds of years, obviously. And then there's a reference tradition. And tradition was a reference to a confirmatory analytic or a confirmatory tradition from the late 19th century that confirmed the understanding of the 18th century meaning of the right to keep and bear arms. But this was slightly modified and clarified. So I explain that it's not appropriate to say text, history, and tradition as a general matter. It's more precise and accurate to refer to the Heller-Bruen methodology as the text and then historical tradition methodology. The way to understand it, of course, is that the text codifies our right to keep and bear arms, we the people. And then, once a modern-day gun control law is implicated by that text, the burden shifts to the government. And the government has the burden to show there's a historical tradition. Hear what I just said? A historical tradition of firearms regulation to show there's some exception to the text-based right to keep and bear arms. And again, the classic example I like to give is, well, there's a historical tradition of preventing people from committing murder with all sorts of weapons. And that would be an example of a long-standing historical tradition from the time of the founding, even before, through today, that would be an exception to your right to keep and bear arms. That the right to keep and bear arms does not encompass the fundamental right to commit a murder with a firearm in cold blood. Why do we know that? How do we know that? It's not in the text, is it? No, you have to look at the historical tradition of firearms regulation, violence regulation, and so on. So that's the difference. It's not text, history, and tradition. It should be text, then historical tradition of what? Of firearms regulation. That's how to understand it. And then again, if there's any ambiguity in the history of firearms regulation, then the text prevails. The text controls. That is the unqualified command. And unless it's unambiguous and crystal clear, there's a historical tradition of some sort of firearms regulation, then that regulation must fall by the wayside. And the last point I want to make is there's a reference here to a judge that says that she just got two briefs. One says that something happened in history. One said that something did not happen in history. But let's be clear in light of what I just said. The historical test is not history per se. It's a historical tradition of firearms regulation. And what is a regulation? A regulation is a law that is enforceable, that's on the books, that is known. It's an actual law. So when a judge says, I don't know history, nobody is asking these judges to go back and study the relationship between Thomas Jefferson and John Adams and whether or not they liked each other or not, or to analyze the poetic language of the love letters between Abigail Adams and John Adams. No one cares about that for these purposes. The type of history that the judges are being told to go back and study and understand is the exact sort of history that judges understand and apply every day. That is legal history. Hear what I just said? Legal history. You go back and you look at the historical laws on the books, and then the cases interpreting and applying those laws. If you want to study the Gun Control Act of 1968, you read the Gun Control Act of 1968, and then you read cases and you read history associated with the enactment of that law. It's about the historical tradition of the law. So when these judges say, I'm not a historian, it's too hard, that's BS. Because every single day in every opinion they write, they're citing to legal precedents. And what exactly are legal precedents? They're history, right? They're legal cases decided 20 years ago, or 10 years ago, or 50 years ago, or 100 years ago. Brown versus Board of Education is still being cited from decades ago. So again, I'll put a link to this New York Times article down below about judges asking for help because they supposedly don't understand history. But I hope when you see these kinds of protestations, you realize just how absurd they are, given the fact that every single day all across America, judges apply not just legal history by citing to historical laws enacted in the past, as well as legal cases decided in the past. They also have to apply those to the facts of particular cases, and the facts that are relevant to deciding a murder case today, of course, occurred when? In the past, in history. So judges deal with history factually and legally every single day. And to feign ignorance and pretend they can't understand the Second Amendment is BS. It's made up. It's because they don't like it, and they don't like you. At least they don't like you enough to trust you with the right to keep and bear arms. That's the harsh reality as I see it in many courts across this country. All right, folks, so there you have it. Hope you learned something here today. Make sure you follow me on X, closing in on 19,000 followers over on X at 4 Boxes Diner. And we will see you again very soon, only after you like this video and subscribe here at the 4 Boxes Diner.
Orders up. Table 2A.